more than the navigation of one of the judicial bends along our journey. The destination remains clear, and as history has consistently shown, it is the final outcome that ultimately matters. I want to thank you so much, distinguished members of the Fourth Estate of the Remain, for coming. Thank you very much. And other invited guests, good evening. First, there is the judgment of Justice Lifu. There is also the judgment of Justice Omotosho. And there is another judgment given by Justice Abdul Malik. But it's important for me to say that in all these three matters, we were sued. We were defending those cases. So we appealed against the orders that were made against the party in those cases. But in the matter that was decided this morning in Ibadan, we went to court and we asked for an order of mandamus, just like I've stated. And there are some persons applied to be joined, and they were joined, and there was no counterclaim. There was no other press before the court, and the court, as it were, went beyond the boundary of the issues that were before the court, and like Father Christmas, awarded to litigants reliefs which were not claimed before that court. It's a fundamental principle of law that the courts, our courts, are not charitable institutions. They do not give unto individual litigants what they have not asked for. Even if you ask for it, you have to prove your entitlement to it before you get it. So we have appealed. Now, am I concerned that these appeals have not been heard? I am not concerned as a lawyer. Now, there are processes that are usually done before an appeal matures for hearing. And these processes are, each party will be given an opportunity of a fair hearing. And that fair hearing means that parties will now file all their briefs within the time stipulated by law. Now, counsel on both sides in this matter have done something that is worthy of praise, because counsel, even without an order by court, were able to now compound the time within which they are supposed to file their briefs, and did so commendably, timeously. But when you file processes, there are usually sometimes arises the need for replies to be made by the parties. And these replies will also be filed. But I want to say that both counsel on both sides have done what is worthy of commendation, and all briefs in these matters are now in the court's files. But I am aware that there are a lot of appeals that have matured for hearing in the Abuja division. And I understand that the court is desirous of doing the kind of Marshall Plan they did for Lagos division. Because in Lagos division, there were more than 500 appeals that were arrived for hearing, and then the court had started to create about 11, 12 panels that sat and were able to dispose of all of them. In Abuja division, I'm aware also that there are more than 400 appeals that are ripe for hearing. So we are praying that the management of the Court of Appeal and leadership in their wisdom will also create that Marshall Plan for the Abuja division, and then set up special panels that will hear all these appeals. If that is done, I am hopeful that our case, being a political case, is one of the cases that will take priority. So very soon, in the nearest future, I'm sure the Court of Appeal will set up a panel that will hear and determine all these appeals. One of the things we do pray probably should be done by that court will be the consolidation of all these appeals, so that there will be one single judgment that will now be binding on all the parties. If you also look at some of these cases, you could see that most of them are somewhat interconnected in their roots, so that the basis of one ultimately is also the basis of the others. So a determination of the key issues in this appeal will determine all these appeals, and will also bring to rest all other matters that are pending in various courts in Nigeria. So we're hopeful. I'm not concerned that the matters have not been heard. I'm hopeful that very soon the Court of Appeal will set up a panel to hear all these appeals.